Next on TVW, the Washington State Supreme Court listens to oral arguments in the case of Port of Seattle versus the Pollution Control Hearings Board. This case was heard in Olympia on November 18th. Okay.
Supreme Court of the State of Washington is now in session.
You may be good. Well, good morning, ladies and gentlemen, and welcome to the Supreme Court on this somewhat stormy November 18th, 2003. I think, as counsel have already been informed, we'll take case number 2 first, then followed by case number 1. One of the counsel in case number 1 is apparently caught in traffic in the big city, so we'll take case number 2, which is Port of Seattle petitioner versus the Pollution Control Hearing Board. Respondent, Mr. Eglick, you have reserved 15 minutes for opening, and Mr. Rivas and Ms. Marchiaro will divide a 30-minute argument, and then Mr. Eglick, is that right? You'll have 15 minutes or whatever portion of that remains for your rebuttal. You may proceed.
May it please the Court, I'm Peter Eglick from Helsel Fetterman, and I'm here representing today a consortium of 5 cities, as well as the Highline School District. I'm also arguing this morning for CASE, a citizens group represented by Rick Poulin, who's seated behind me. This case arises out of the Port's challenge to the Pollution Control Hearings Board's unanimous correction of a politically skewed Clean Water Act Section 401 certification. In the form issued by the Department of Ecology, the certification would have allowed contaminated fill and stormwater laden with toxic metals to be released into area Class AA fish-bearing streams. What you're being handed right now is an excerpt.
I wanted to ask about that. There's 3 creeks here, Des Moines Creek, Miller Creek, and
Walker Creek, Your Honor.
Walker Creek. Do salmon spawn in these creeks?
Well, they are fish-bearing. There are salmon. They were not found to be subject to the Endangered Species Act, but they are fish-bearing and do have spawning fish in them. Yes.
You may be going to cover this anyway, but your understanding now of the third runway would fill in this canyon or ravine that goes down into Miller Creek, is that right?
Yes, it's as the board described it, it's a canyon that's 150 feet deep, and it would be filled with approximately 20 million cubic yards of fill.
It wasn't clear to me from the findings whether is the creek covered and then has a culvert that carries the water through, or does it come? I saw in there that said comes within 50 feet of the creek.
That's correct, Your Honor. In places it does, and portions of Miller Creek are going to be relocated. That's part of what the mitigation the port has offered would do, is for about
so they won't use culverts, they'll relocate the
That's the theory in a fairly artificial way. Yes, that's the theory, Your Honor. How the third way is constructed turns on this case, and I want to emphasize this is not about the merits of the third runway project, should it be built or not, but it's about how it will be built and how it will be operated. The Clean Water Act and state water quality standards, including the federal and state anti-degradation mandate, which is paramount under both the Federal Clean Water Act and the state Clean Water Law, RCW Chapter 90.48, don't have a sliding scale of compliance depending on the politics or popularity of a project. If the 5 local governments I represent here today allowed such considerations to enter into permitting decisions, this court would rightly reject such an approach. In fact, this court has in the past rejected such an approach. The port has filed by far the broadest of any of the appeals here. The port's issues, if granted or upheld by this court, would eviscerate the protections imposed by the Pollution Control Hearing Board. Therefore, because time is limited and the issues that ACC and CASE have raised are fully briefed, I'm going to start with a discussion of the port's attack on PCHB condition number 8. And if you recall, that's the condition concerning the synthetic precipitation leaching procedure, or SPLP. Now, as we just discussed, the signature feature of the port's third runway proposal, as the board itself pointed out, is depositing 20 million cubic yards of fill in a wooded canyon, which encompasses Miller Creek. The bottom of the canyon lies 150 feet below the level of the airport's existing runway. To give you an idea, and this is in the record, 20 million cubic yards of fill is equivalent to 40 football fields of fill, each stacked 300 feet high. It's an unimaginable quantity. There's another analogy given by Professor William Rogers, who submitted an amicus brief on behalf of the Sierra Club and over 10 other environmental groups across the state. And he noted that this amount of fill is equivalent to 5 times all of the material dredged by the Army Corps of Engineers out of the 4 Snake River reservoirs, plus associated projects, over 20 years. The quality of the fill deposited by the port is critical for the health of the aquatic resources, which under state and federal law must be protected from degradation. After a 2-week trial, review of voluminous testimony, you have the record before you, it's over 50,000 pages, the board found that the port's proposal for placement of fill was wanting in virtually every key respect. For example, the board found that the limits on toxic materials in the fill, what are called numeric fill criteria, I call them limits on pollution, were set too high, above natural background levels, which would allow use of contaminated fill. And the board determined that the reasonable assurance standard of the Federal Clean Water Act was not met by a process incorporated into the 401 certification for acceptance of fill, which had tested as contaminated. In other words, which had already tested as violating.
Excuse me, didn't the Corps of Engineers approve the certification? I mean, doesn't that sort of undercut your argument?
Well, the Corps of Engineers reviewed whether or not it would incorporate the PCHB conditions, and for a number of reasons, both discretionary and legal, it said it would not. Those were reviewed by the federal court on an arbitrary and capricious standard. The Corps, in fact, did not have the benefit of having sat through the 50,000-page 2-week trial, and in addition, the Corps' review was very much based on the U.S. Fish and Wildlife Service Endangered Species Act review, which itself was focused on a very narrow issue, harm to, for example, habitat for particular endangered species. So I think the two determinations operated on a different review, on a different standard. And on top of that, it's important to keep in mind the purpose of Section 401 of the Clean Water Act. Its purpose is to make sure that water quality is not denigrated, and when it was adopted, when Section 401 was adopted, the legislative history indicates it was supposed to backstop in just this kind of situation to make sure that if the Army Corps, that the federal government allowed something, the state would be there, have the authority, and have the mandate to say, no, that won't work. So they're really two separate regimes, Your Honor.
Counsel, I understood that the SPLP procedure, or maybe that's a redundancy, is an accepted procedure for testing these contaminants in both the federal regime and other states. Is that correct?
It is used for some purposes, and it's important to understand what the board did and did not do. The board did not say SPLP in all cases is a bad procedure or a bad test. The board looked at the SPLP work plan, which had been attached to Ecology's 401 certification and was included to allow importation of fill that had already failed the numeric fill criteria, and it said that work plan won't work. The work plan involved using the SPLP test on a certain sampling mode with certain assumptions and so on. And the board analyzed it from all of those aspects and said it won't work. There may be some circumstances where it would, but one of the things the board found here that it was too blunt an instrument. And the record was very clear on this. I think the best analogy is you're trying to determine whether it's freezing outside, and you're only using a thermometer that most times will only register down to 50 degrees. Too blunt an instrument, and that was one of the major problems the board found here in its decision.
Well, is there anything to the fact that the SPL procedure they were only proposing to use it to measure the surface waters rather than groundwaters, and if that were extended to measure groundwater contaminants, would that meet your issue or address it at least in some part?
If, and I don't want to kind of recraft the condition for the port or ecology here, but there would have to be a lot of calculations done to determine how to integrate the SPLP procedure and solve that shortcoming. That wasn't done here on this record, and that would only solve one of the problems the board found.
What are you asking us to do?
Pardon me, Your Honor?
What are you asking us to do on this issue?
Well, on this issue, we've said the board made the right decision. The port originally appealed and said the board did not make the right decision. The port has since said, because of legislation passed in the last session, that really the board's decision is moot. We're asking you to say, A, the board made the right decision, and B, the legislation does not make the board's decision moot.
You say the right decision, you're talking about Condition 8, is that what you're?
That's correct, Your Honor. And it's important to understand what Condition 8 did. Condition 8 didn't say SPLP is a bad idea out in the universe, it could never be used. It said, on the standard we must apply here, reasonable assurance that water quality standards will not be violated, SPLP will not work in this case. Now, the legislation that the port is relying on says if ecology has required SPLP, then that is ratified by the legislature. We don't think that legislation gets the port where it really wants to go. What it may do is say, okay, if ecology uses SPLP, then the board decision says there's no reasonable assurance. The end result being there's no certification and no ability to go ahead. That's one of the problems with the legislation. Stepping back, and these may be issues the court jurisprudentially may or may not want to reach, the legislation attempts to essentially adjudicate what a federal standard will result in this particular case. The federal standard says you must have reasonable assurance that water quality standards will not be violated. That's in the Federal Clean Water Act. The legislature, according to the Port and Ecology, presumed to say, well, in every case, SPLP will meet the reasonable assurance test.
Well, how can you say that when the legislature included the words may use? I mean, if they were saying that in every case this manner of procedure or testing will satisfy the requirements of a 401 certificate, how would they then have used the word may?
Well, I agree, Your Honor, in the sense that what I was characterizing is what I think the Port and Ecology are arguing. I think the actual language of the legislation doesn't, as I said, get them where they want to go. The fact that ecology may use it, in our view, doesn't bind the PCHB or make it conclusive. If their argument is correct that it does bind the PCHB and somehow make it conclusive, that immediately is a violation of separation of powers and a violation of the Supremacy Clause. There are two very key cases we cited for those latter two propositions, Tacoma versus O'Brien on the separation of powers, and I'd urge the court to examine that because I believe it's on all fours with this situation. But the other case is the Northern Plains case out of the Ninth Circuit, the Northern Plains Resource Council case, which is very clear that the state legislature cannot legislate in a way that essentially tries to preempt or change the federal standard. Professor Rogers in his amicus brief cites another case that I think is also instructive on that point. That is I'm going to get this wrong, I know, but it's the Mikuziki case. It involves, I believe, a Native American tribe out of Florida. It concerns the Everglades. So those are all cases on point that say that legislation, our position on it is you can't get there from here. It didn't do what apparently it was intended to do, which was preempt an adjudication by the PCHB. And I want to emphasize my clients, my city government, spent a lot of effort and public resources going to the quasi-judicial body that the legislature in a statute said they should go to have this issue, for example, fill criteria and SPLP resolved. Huge amounts of public money and effort were spent, good faith, scientific testimony, the works. And now we have a bill that the legislature passes that some folks think says that's out the window and your hands are tied. We simply don't agree with that. We think it doesn't get us there and it can't legally do that. Now, Your Honor, I do have other issues I'd like to address, but I'd like to reserve the balance of my time, if I could, for reply.
Very well, Mr. Gregley.
Thank you.
Mr. Rivas.
Thank you, Your Honor. May it please the court. My name is Gil Revis. I represent the Port of Seattle in this case. The Port is pleased to be here to present its arguments on a very important public transportation project, construction of the third runway at Sea-Tac International Airport. We're here on an appeal of a decision by the Pollution Control Hearings Board. The Department of Ecology recognized that there is reasonable assurance that the Port's project would not violate water quality standards. The Board affirmed that decision, yet the Board added 16 conditions, and the Port is appealing 6 of those conditions. Now, this project has been under study for more than 15 years. It's perhaps the most intensively studied project in the history of the state. In 1992, the Puget Sound Regional Council completed a programmatic environmental impact statement regarding the air traffic needs of the region. In 1996, the PSRC identified the third runway as the preferred and only feasible alternative. And one of the reasons for that decision was that this particular location would have fewer environmental impacts, particularly with regard to wetlands, than other locations that were studied. From 1992 until 1996...
Is it the Port's position, when you say that this will not degrade state water, or will not create a condition that's below state water quality standards, is it the Port's position that the water quality will be as good after this third runway is in as it was prior to the building of the third?
That's correct, Your Honor, and that's what's required by the anti-degradation standard. In fact, there are things that the Port is doing that will probably...
You're going to bring in all this, I'd call it dirt, but we call it fill, I guess, for purposes of this proceeding. You're going to bring all this in, put it in there I guess it goes right next to Miller Creek within 50 feet, is that right?
In one location.
Some places, and then some places it will cover the existing creek?
It will cover certain wetlands in that creek, and the reason that Miller Creek is being rerouted in certain locations is so that it can continue to flow.
So
now,
you're going to alter the historical course of this creek and bring in all this fill, and the water quality is going to be just as good afterward as it was before?
We believe it may actually...
I got to tell you, I find that difficult to...
We believe it may actually be better, Your Honor. Let me first address the issue on Miller Creek, because Miller Creek is not in its historic location. It runs through an agricultural area known as Vaca Farm, and in certain locations it resembles a ditch, which I think the Board acknowledged in its findings. So what the Port is doing is actually improving that particular creek for the purposes of wildlife habitat.
This ravine that you're filling in was the historic location, wasn't it?
No, Your Honor, it's actually been rerouted. Miller Creek sort of runs from the northeast of the airport down around where the fill is going to be placed. Now, in certain locations, the fill is going to move so close to Miller Creek that Miller Creek has to be rerouted. But the present location of Miller Creek was created as a result of a peat farm that was located there in that Vaca Farm area. So it's been channelized, it's been ditched. The Board, in fact, concluded that it was degraded. So some of the steps that the Port is taking, particularly with regard to Miller Creek, are specifically designed to improve aquatic habitat there. The Port is also eliminating a number of uses in this area where the fill is going to be placed, such as septic systems and water uses and other measures that are all described in the record, so that in the end, the goal is to improve the water quality in those streets.
As I understand it, the water that will collect on the runway, which will be immense, I mean, this is a huge runway, isn't it?
That's correct, Your
It
Honor.
will be diverted into an underground reservoir, or some sort of a holding place, and then it'll be pumped into the creek at when there's low flows, is that right?
More or less, Your Honor.
Is that water going to be pristine, or is it going to be in good shape when it comes into the creek?
Let me address first what the system does, Your Honor, because the system is not unlike most stormwater detention and treatment facilities at various projects around the state, because stormwater is detained in order to prevent high flow impacts such as scouring and erosion of streams. In this particular project, it's also being held a little bit longer so that water can be added back to the streams. Now, what's happening here is that the Port's infiltrating some of this water through normal ponding. So you create a pond, and the pond holds the water for a certain period of time, after which it can be pumped into a stream or into a wetland or simply down the normal water course. But the Port's proposal treats that water as it sits in the detention, whether it's a pond or a vault, because the contaminants or pollutants settle out, and then the water can be released when it's cleaner than when it went into the vault. So there is treatment. And the ecology concluded that based upon all of these mitigation measures, that there is reasonable assurance that water quality standards would not be violated. And the board agreed with that.
So all the, whatever airplanes put on the runway, gas or oil or whatever comes, I'm sure there's some sort of, some impact on the runway. That will all be cleaned out then?
Well, Your Honor, the one thing to understand about the way the runway works in the system is that not all of the stormwater goes to these streams. What the port has done in design of this facility is route a good portion of the stormwater to what's called the Industrial Wastewater System, the IWS, which does actually run through some additional ponding and some additional treatment before being discharged to Puget Sound. And so not all the stormwater goes to the stream. Some of it goes other locations, and that's the subject of a separate federal permit issued under Section 402 of the Clean Water Act. Now, the problem on the runway is primarily with regard to glycols from de-icing events, and that the ecology considered that issue very carefully and decided that the port's system for detaining this water wasn't going to cause any problem with glycols in the streams. But most of the other contaminants and fueling activities and all of those things occur in a separate location that drains to the IWS instead of draining directly to these streams. Now, this project, in 1997, the FAA issued a formal record of decision concluding that no prudent alternatives existed and that all reasonable steps have been taken to mitigate environmental impacts. Since that time, U.S. Fish and Wildlife has decided that the project does not violate the Endangered Species Act. That was concurred in by National Marine Fisheries Service. And in December of 2002, the Army Corps of Engineers granted the port a permit to fill wetlands under Section 404 of the Clean Water Act. That decision was appealed to Judge Rothstein, and it was upheld. Now, the 404 permit is significant because the 401 certification is necessary in this case primarily to tell the federal government whether this project complies with state water quality standards. So the decisions are very similar in terms of what the Corps was doing versus what ecology was doing here.
So the
Now-
Corps would have been aware of the plan to test the soils that would be used as fill with this SPL procedure, and the Corps was satisfied that that would result in testing that would demonstrate that the levels of contaminants did not exceed the federal Clean Water Act.
That's correct.
Level of ceilings.
And that was the Corps made a couple of decisions. One was that the fill criteria did not have to be incorporated within the federal permit because the board's fill criteria were developed after the one-year period in which the state had to provide a certification. But if you read Judge Rothstein's decision, I would urge you to do that. Judge Rothstein's decision that says that was not arbitrary or capricious because upon review of the fill criteria themselves, some of them simply don't make any sense. For example, one that Judge Rothstein identified was below natural background limits. So all of this is covered in our briefing. We believe that ecology made the correct determination with regard to fill criteria because ecology, after all, is the primary agency that on a daily basis considers questions such as how much of a particular constituent can exist in soil without threatening water quality. And both sides have argued the deference question, but it's our position with regard to a highly technical issue such as SPLP or fill criteria that some deference needs to be given to ecology's expertise in that regard.
And what deference is to be given to the board?
We believe that the board should be given deference with regard to its own factual findings as required by the substantial evidence standard. So I don't believe you can set aside the board's factual findings without substantial evidence. But in evaluating some of these questions of judgment with regard to highly technical matters, I think you also need to look at the standards that ecology selected. There's a couple of cases on this, I believe, that are relevant. The one I would like to indicate to you is the ecology versus the PUD of Jefferson County, number 1, which is known as the Elkhorn case. And this court stated specifically that it is well settled that due deference must be given to the specialized knowledge of an administrative agency. Here, ecology was exercising its expertise in judging the appropriate in-stream flow rate for the Elkhorn project. Therefore, in analyzing the board's decision under the clearly erroneous standard, we also give due deference to ecology's expertise in this area. So there aren't many cases that discuss our precise factual situation where you have a decision by ecology and a decision by the board. So I think there's an interplay here. This court has previously recognized that ecology's deference, particularly on ecology's judgment on technical issues, should be given deference. Let me jump to condition number 8, which is SPLP, because I think that is one of the more important issues in this case, and it's our view that the board simply got it wrong when they prohibited SPLP. SPLP is a leaching test. Its sole purpose is to determine how much of a particular metal or other naturally occurring substance can leach out of soil. If it doesn't leach out, it's not a threat to water quality. And that's why ecology included it in the 401 certification. Now, there's some confusion here about what SPLP is and isn't, so I'd like to address that for just a minute. SPLP works like this. You essentially take soil or rock, whatever the case may be, you put it in a jar, add acidic water. It has about the acid content of acid rain, so it's an aggressive test. You agitate that for 18 hours, and then you pour the water out. That's the end of SPLP. That's what I call the jar process. Now, later what happens is that water is analyzed in a laboratory, and it's compared against whatever standards it's required to be compared against. And that's an entirely different analytical process that's totally separate from SPLP. And that's what I call the lab process. So I believe what the board did, and as the court noted earlier, SPLP is widely accepted. It's accepted by EPA. It's in ecology's regulations. It went through notice and comment. It was accepted by the Corps of Engineers for use at this project. And it was also, that decision was affirmed by Judge Rothstein. But I think what the board did is misunderstood the SPLP process, because as we noted in our briefs, the board said it had 4 concerns about use of SPLP. All 4 of those relate to the lab process and not to SPLP itself. So our position is that the board, number 1, acted arbitrarily or capriciously because it threw out the jar part, SPLP, when its concerns were really about the lab part. And I won't go into detail about our arguments on the lab part concerns, but our position is with regard to 3 of those concerns, there's absolutely no support in the evidence for those 3 concerns about the number of samples, the detection limits, and the water quality standards not being available.
What about counsel's argument that your instrument is too blunt?
Well, Your Honor, I think that what the board did is unfortunately identified these concerns that based upon a proposed finding of fact that was submitted by the project opponents, ACC and CASE, that simply doesn't have any evidentiary support. So I think it's correct that the board was trying to identify some particular problem with this whole leaching procedure. Unfortunately, what the board did is misinterpreted the evidence, and I think there just isn't any valid evidence to support those concerns. So I think the argument would be valid if the board had decided we don't like the SPLP work plan and thrown out the work plan. That's not what the board did. The board said you simply can't use SPLP, which is an entirely different process from the analytical issues that the board had concerns about. So our position is, in this case, that SPLP should be reinstated because it wasn't supported by, the board's decision was not supported by substantial evidence. The board's decision was arbitrary or capricious, and it was overruled by the legislature. Which takes me into the question about SSB 5787, the Senate bill. I don't want to spend a lot of time on it, but I do want to talk about primarily the separation of powers issue. Because I believe that the constitutional challenge here really simply misinterprets the bill. It's our position that the bill does not adjudicate any facts. It does not tell this court how to resolve any review of the board's finding. The bill does not compel the conclusion that ecology had reasonable assurance. What SSB 5787 does is establish SPLP itself as a valid scientific tool for determining whether water quality violations could occur. And the legislature is in the business of determining what is or is not good science and establishing scientific tests for the courts and administrative agencies to apply. Two examples of that cited in our brief are breathalyzer tests and DNA tests. So that's a function of the legislature to engage in. Because the legislature was not attempting to adjudicate any facts, however, I think the Tacoma versus O'Brien case is simply inapplicable. That was a case where the court said contracts that were entered into, specific contracts, have now become impossible to perform. So I believe that that case doesn't apply to the facts of this case.
There's also a challenge that this particular piece of legislation also violates the federal preemption doctrine insofar as it interferes with the Clean Water Act.
Let me address that quickly. I think there's an easy answer. It's simply not true to say that SPLP violates the Federal Clean Water Act because it's an accepted test by EPA. EPA administers the Clean Water Act on a national basis. It was also accepted and approved for this project by the Corps of Engineers, which implements Section 404 of the Clean Water Act on a national basis. It was approved by Ecology when Ecology promulgated regulations. It was approved by Ecology for this project, and Ecology interprets and applies the Federal Clean Water Act in the state of Washington. So all of those authorities clearly hold that SPLP is consistent with the Clean Water Act, and I don't believe it's true that there's any conflict at all between SPLP and the dictates of the Clean Water Act.
It seems as if the use of the words reliable method are valid and reliable, I guess, is of course the focus here. Is that inaccurate, however, based on the fact that it is widely accepted, that it is in fact valid and reliable?
Well, I think what the legislature was trying to do is cure a problem that it perceived from the board's decision, that the board essentially cast some doubt on the validity of SPLP and Ecology's ability to use it. So it's our interpretation of that statute that the legislature was trying to make it clear that that was an error, that this is a valid and reliable test, and you simply can't throw it out, particularly in this case where the reasons why you're throwing it out are entirely unrelated to the SPLP process itself. What I'd like to address now, because it sort of covers a lot of issues here, is the substantial evidence standard itself. Because what ACC has done in its briefing is essentially try to avoid the substantial evidence standard by casting its arguments as legal arguments. The best example of that is, while ACC says it's only challenging a few issues, they're actually challenging the ultimate decision reached by the board, by Ecology and by the board, which was there is reasonable assurance that water quality standards will not be violated. Now, by casting that as a legal issue, the ACC avoids discussing all of the contrary evidence to its position and instead only talks about evidence as favorable to its case. Now, the truth of the matter is reasonable assurance is a mixed question of law and fact. And under this court's decision in Shue versus the Department of Ecology, the factual component of mixed questions has to be reviewed under the substantial evidence standard. So in reviewing ACC's arguments, I think it's important to note that what they're asking the court to do on many of these questions is simply to reweigh the evidence, that they are choosing their favorite witness on a particular topic and saying essentially if you believe that witness, then the board made a legal error. But this is not a purely legal determination, it's a factual determination.
What about condition 16? The port shall obtain a water right to use water as proposed mitigation under the low flow plan.
Your Honor, I think if I can jump to the crux of that issue, it's essentially that the port is not using the water. The port's system is designed to take out certain water and detain it for high flow purposes, to release it slowly, to mitigate high flow problems, and to mitigate low flow problems.
If you had too much more water than you needed and you used part of it to water a golf course or something like that, would you be using it then?
Yes, and we've acknowledged that in our briefing, that that would require water.
But you're not using it if you put it back into the stream.
Exactly. It's taken out, it's put back at exactly the same time in the same quantities that it was taken out. So it's simply not, it's not a use of the water. And Section 90, RCW 9054-020, subsection 11, talks about water management programs as distinguished from subsection 1, which talks about uses of water. And I think the flaw in the board's argument and in ACC's and CASE's argument is there's simply no rational way to distinguish between mitigation, detention of water for high flows, and low flows. So there's no reason to conclude that the low flow requires a water right and normal stormwater management doesn't.
Council, before you stand down, I wanted to ask you a question. I didn't see it in the briefing, but it seems as if your opposing counsel is almost standing in the shoes of what they consider to be senior water right holders. And I didn't see any challenge to their standing to assert other persons' water rights. Is that because there is some sort of attorney general scheme that allows them to stand in the shoes of other water right holders?
I'm not aware of anything that would allow that. I think that everybody acknowledges that even if the port were granted a water right here, it would be a junior water right to other water users. So I don't think that that's necessarily an issue that needs to be resolved by the court. Thank you.
Thank you, Mr. Rivas. Ms. Marchioro? Sit.
May it please the Court, my name is Joan Marchioro. I'm an Assistant Attorney General, and I represent the Department of Ecology in this appeal. When the Court conducts its thorough review of the record and looks past the rhetoric of counsel, you will be left with but one conclusion. There is reasonable assurance that the port's project will comply with applicable water quality standards. Ecology makes a reasonable assurance determination by first determining whether, through a preponderance of the evidence, the project can and will meet water quality standards, and by identifying any uncertainties that are raised. And second, by addressing those uncertainties by imposing conditions that reduce or remove the uncertainty. In sum, ecology makes a determination that the project is feasible, imposes conditions to ensure that the project is properly constructed, and then has its enforcement authority to require compliance where necessary. As the record demonstrates in this case, ecology had reasonable assurance with respect to had substantial evidence to make a reasonable assurance determination as to the port's project and its compliance with water quality standards. The conditions requiring the port to provide for additional submittals are prescriptive in nature and simply require a refining of the proposals already provided to ecology during the process. In addition, as permitted under Section 401D of the Clean Water Act, ecology imposed monitoring requirements in the 401 certification. That monitoring data will be used to determine whether the port is in fact complying with water quality standards, to determine whether the project is having the anticipated environmental impacts, and to evaluate the effectiveness of the required mitigation. If the port is not in compliance with water...
I think ACA and CASE are arguing, however, those monitoring conditions, if you will, doesn't suffice, that you shouldn't have issued this certification if, in fact, you have to monitor to ensure that it's going to be all right.
Well, Your Honor, as I stated, Section 401D specifically permits or requires monitoring. And the important thing to remember about a 401 certification, as with many other permits, it's forward-looking in nature. And so there's an element of prediction that's going into the decision. And in order to determine whether that prediction is accurate, ecology imposes monitoring, and it imposes it in a variety of different permits that it issues. But in a 401 certification, it's quite important to have the monitoring to determine whether those predictions were accurate, and then to be able to either enforce where necessary or apply adaptive management to adjust the different aspects of the proposal so that it will come into compliance with water quality standards. Now, the board's ruling in this case creates several issues for ecology regarding how it conducts its business. Now, for instance, the board's authority to limit the full implementation of an ecology regulation, the board's ability to override ecology's technical expertise when there's no evidence in the record to support that, and the scope of review of the board's review of ecology's decisions. And I want to focus my argument on two issues raised in ecology's briefing. And the first is the board's limitation of the full use of the water effects ratio study and the board's rewriting of the fill criteria established by the ecology's technical expert.
Could you refer to them as to which condition those are?
I'm sorry, it's conditions, I believe 5 and 7. As to condition 5, the 401 certification provides that the port cannot discharge stormwater from new impervious surfaces without conducting a site-specific water quality study, which is also referred to as a water effects ratio study, and which is provided for in ecology's water quality regulations. Now, the purpose of the study is to evaluate the quality of the stormwater runoff and then the receiving water to determine whether the numeric water quality needs to be adjusted. And that ratio serves as a local translator, taking into account local conditions, which is in contrast to the criteria themselves, which are developed using laboratory water. Now, the results of the study will be used to determine whether specific effluent limitations need to be imposed in Ecology's stormwater discharge permit, the NPDES permit. Ecology's testimony of Kevin Fitzpatrick, and the board found in its order as well, if the study indicates that an adjustment is needed, that does not result in a lessening of the stringency of the water quality standards. Now, despite that testimony, the board imposed a condition limiting the full use of the water effects ratio study, and in doing so, it committed an error of law. First, it ignored a validly promulgated regulation by the Department of Ecology, and that regulation was not challenged below on its face or as applied. Rather, the board, on its own initiative, limited or created an exception to that regulation. Secondly, the applicable water quality standard does not impose such a limitation, and in fact permits the full use of the water effects ratio study's results. And finally, the EPA, which oversees the Clean Water Act and approves of Ecology's water quality standards, has recognized the use of the water effects ratio study to adjust its generic water quality criteria. The board committed an error of law by ignoring the terms of Ecology's regulation, and Condition 5 should therefore be stricken. As to the fill criteria, which is in Condition 7, the board committed error in that regard by rewriting Ecology's fill criteria developed in the 401 certification. The purpose of the fill criteria is to confirm that no contaminated fill will be used in the construction of the third runway. Condition E of the 401 certification sets forth stringent protocols that the port must observe in selecting fill sites, and then numeric fill criteria for the testing of that fill to ensure that it is not contaminated. Now, despite the unrebutted evidence presented by Ecology establishing that the fill criteria was protective of water quality standards, the board ignored that testimony and substituted its own judgment for Ecology's technical expert. There's no evidence, let alone substantial evidence in the record to support the criteria the board developed. As this court has recognized in Ecology versus PUD number 1 of Jefferson County, Ecology staff does have specialized knowledge and expertise in technical areas it is charged with overseeing. And the deference that should be given in this case, especially in a case such as this where there is no evidence in the record to support the board, is that deference should be given to Ecology's technical experts when reaching a technical determination.
If there had been evidence or substantial evidence, would the board be able to substitute its judgment for that of the Department of Ecology?
Well, Your Honor, to the extent that there is evidence in the record and the board is weighing the evidence and the board is choosing which is more credible evidence, yes, in fact, it can substitute its judgment. But with respect to the fill criteria, there was no evidence. There was no testimony by anyone that stated that the fill criteria was not going to protect water quality standards. And the testimony that was presented with respect to the fill criteria was that it would be protective. And yet the board deviated from that testimony and crafted its own fill criteria. There's no evidence in the record to support the board's condition number 7. Ecology requests that that condition be stricken and the original criteria in the 401 certification be reinstituted. As demonstrated by the record, there is reasonable assurance that the port's project will comply with water quality standards. This court should strike the board's conditions limiting the use of the water effects ratio study, rewriting the fill criteria, and rejecting the use of the SPLP test procedure because those conditions are not supported by substantial evidence or the law. And finally, the court should conclude that there is no legal support for the board's modification of the de novo scope of review required by the APA and the board's own rules. Thank you.
Well, before you stand down,
Yes.
It's Ecology's position that if this project goes forward with the reduced number of conditions that you've advanced in your argument, that applicable water quality standards in this state will be met? Is that?
Yes, Your Honor. What the board did was added conditions on top of Ecology's reasonable assurance determination, and if those conditions are removed, the original determination as to reasonable assurance stands. So
you agree with Mr. Revis that the the condition of that water will be just as good as it was before they built this third runway?
Well, Your Honor, you need to take into, and I do agree with Mr. Revis and the port on that
I
regard.
shouldn't say you, I mean, you're the department.
Yes, the Department of Ecology does. And as Mr. Revis pointed out, and I think it's important to note, is what we have is a highly modified system. First off, you have Vaca Farms, which is a peat wetland that has been farmed over the years and highly degraded. And that is part of the area where Miller Creek runs. Miller Creek will now be put back into a more natural channel. There's significant benefits that will be brought to Miller Creek, both in terms of restoration activities to the creek itself, as well as the removal of homes and certain activities that cause additional pollution, such as runoff from fertilizers.
Do these existing wetlands that are in the area, and I understand there's about 20 acres of them in the
Yes.
site, do they currently affect the quality of the creeks in a positive way?
To the extent that the wetlands are functioning, they should have some water quality benefit, because that's the nature of a wetland. The concern that
So part of some of the conditions here are that wetlands have to be restored, the ones that are to be taken out.
yes, some of the wetlands will be restored, some
Some of
wetlands
them
will.
they're going to be restored down in Auburn, which is quite a long ways away from the
Well,
airport.
and looking at what's required as far as the Clean Water Act, certainly there is in-basin mitigation, and if the court looks at the Natural Resources Mitigation Plan, it will, and the testimony of ecology's expert Eric Stockdale, it'll find that, in fact, the mitigation that's in-basin replaces the wetland functions and values, with the exception of the avian habitat, which raises a concern for airline safety, bird strike hazards. Those functions and values are being replaced in basin. And there's the addition of the Auburn mitigation, which will provide the avian habitat.
But but the Auburn restoration won't affect the quality of the water in these creeks, will it?
Well, not in the basin, but it will be within the watershed, so to the extent that there's a watershed benefit.
The larger watershed?
Yes, and if you look at 9074, it specifically allows for ecology to consider an out-of-basin in watershed resource inventory area mitigation plan, but does not require ecology to accept that plan unless it determines that the plan will provide equal or better functions and values. And in fact, ecology did review very closely the Auburn plan and found that it would meet those standards, as well as the scientific standards that govern wetland scientists.
Well, low flow has been an issue, and your opposition says that ecology's own expert didn't really agree. They're talking about Mr. Kelly Whiting, who also works for King County. What's your response to that?
Well, Mr. Whiting provided a review of the low flow plan for ecology because the ecology does not have an expert in that area. And Mr. Whiting had several comments with respect to the plan, but he did find that the plan was going to be feasible. It needed to be refined to determine the exact impact.
And in their brief, they said that the validation report for the Des Moines Creek was not even done at the time of the hearing. Has it been done since then, or what are we to make of that?
I believe that the validation report was completed just prior to trial, and I honestly, I don't recall it specifically. To the extent that it has been provided, it's been reviewed by ecology, I believe. I do not know if that's in the record, and I'd only be speaking from sort of a scattered memory on that.
Oh, I was referring to page 43 to 45 of their brief, their reply brief.
Okay, I'm sorry, I don't have an answer to that.
Thank you, Ms. Marchioro.
Thank you.
Mr. Eglick, you have 17 minutes.
Thank you, Your Honor. Your Honor, I want to start with some comments made by Ms. Marchioro. She kept on emphasizing the need for deference to ecology's experts, but she did not name any experts. The reason for that is because, by and large, the board's findings are actually based not just on testimony from ACC experts, but on testimony from ecology experts. They consistently, in their depositions, some of which were incorporated into the record, and in their testimony before the board, actually supported the positions that ACC took and that the board ultimately hit on in its findings. If you look at the testimony, for example, and the documents that we have from Dr. Chung Yi of the Department of Ecology and from Peter Komet, who's Ecology's senior toxics cleanup engineer, they support that testimony, that evidence supports the board's findings with regard to the numeric fill criteria. That's why the board made the findings it did, because it was deferring to ecology's experts, not, if you will, to ecology's political decision. And that testimony, that evidence is in the record. For example, if one looks at record 17357, it's one of the seminal memoranda from Peter Comet, the senior toxics cleanup engineer, talking about what's needed for the fill criteria. And that's the kind of evidence the board relied on. So in a sense, the deference debate is almost beside the point, because ecology's expertise is what the board did rely on. Supported, of course, by ACC testimony as well. I did want to answer a question that the Chief Justice directed to my colleagues, and that is, where does the stormwater from the runways go? My understanding of the record is that the stormwater from the runways does not go to the industrial wastewater system. It goes to the runoff, that goes into the discharges, that goes into the streams. That's the record. There may be other things that go to the industrial wastewater system, but not the massive runoff from the runways. And in addition to that, I think it's important to point out that
It'd go from the runway to, how does it get down to the?
there are points that collect it, and then it is discharged into the streams at various discharge points. I think one in particular is focused on in the board's decision. I may get the number wrong, but it's something like SDS 3, I believe, is one that it says is a discharge point that's exclusively stormwater runoff.
These are these underground retention?
No, Your Honor, these are, well, there may be underground retention involved in collection of the stormwater, but ultimately the stormwater from the runways ends up in the streams. Now, it may be retained in some places to level the peaks, but it ends up in the streams, not in an industrial wastewater system or a treatment, as I think was suggested. And it's also important
So there won't be any, you're saying there won't be any treatment of the runoff from the runway?
Well, that's one of the issues in the case, is what kind of treatment there will be. And as you know, the board called for more treatment than what had been proposed. And that has to do with the question of whether we go from the menu of treatment that's limited to what's called, for example, bioswales, essentially a grass-lined ditch, or whether we go to actual treatment with active filters and sand filters and that sort of thing. The board required more, but that's the kind of treatment that we're talking about. It's relatively limited, and of course, we've raised the concern that the way the board's decision is written, it requires more, but allows ecology the leeway to later take it away in a subsequent NPDES permit. And that's one of the issues where we've disagreed with the board and said it wasn't tight enough. But I want to distinguish something here. The low-flow mitigation water is presumably going to be gathered from stormwater runoff also. That is gathered, as I understand it, in separate vaults. And that water, there is a suggestion will be treated, but one of the issues before the board was how? How are you going to do this? You're going to hold this water for 6 months or more and then put it out in these streams that require life support because of all the revamping of the watershed that's been done. It's, one of our experts called it an anorexic slug of dirty water. And that's one of the issues that wasn't really resolved before the board, how that water that's put in on low flow would be treated. As long as I'm talking about low flow augmentation and that separate system to collect stormwater and discharge it in perpetuity at set rates at set times, I want to emphasize that we think that issue is clearly resolved by the water code. It's a beneficial use. The law is clear that when you collect water and then discharge it, use it for this kind of purpose, that is maintenance of habitat, that is, by statute, we've cited the portions of the statute in our briefs, that is a beneficial use, and that should be the end of the discussion. It's very different than a stormwater system, for example, that relies on infiltration, ultimately then ends up back in the groundwater or as base flow, or some other non-governed system for release. In other words, there's no requirement that you release in perpetuity. There's no requirement that you release at specific rates. You're just collecting stormwater to level off the peaks so that the streams don't get scoured. The beneficial use makes the difference, and that's why the water right was required here by the board. If if the idea is that there ought to be an exemption for this kind of beneficial use, there's a way to do that, and the legislature can. It has in a number of instances. For example, we pointed out in our brief, in the last legislature, there was an exemption created, I believe, for small irrigation reservoirs, where farmers collect presumably stormwater, some kind of water, and then release it for irrigation. Well, the legislature created an exemption from the water right requirement in the statute.
Well, there'd be no question there if they were using it for irrigation purposes. That's clearly a beneficial use.
Right, but the port does a lot of things, but it's not farming yet, Your Honor. So we're looking at something here that's very different and must be done in perpetuity to give life support to these streams. And that's why
It's a mitigation tool, isn't it? I mean, it's just making sure that the impact of the runway doesn't have an adverse effect on these streams, and it's simply trying to replicate what would happen in nature if it weren't for these runways. Isn't that correct?
And so were the two previous mitigation plans for augmenting stream flow, both of which ecology and the port acknowledged required a water right. Somehow when we got to this one, all of a sudden, the water right requirement was dispensed with until the board said, no, you cannot do that. But the fact that it's a mitigation tool in one sense doesn't take it outside of the water code, because that's what the law is. And the statute is clear, and there's no exemption for this. I did want to emphasize that water quality, in our view, will not be maintained if the board decision is not upheld. That's absolutely critical here. The board rules out the SPLP process, and I want to emphasize that the board rules out not the test by itself, but the process. That was not a process that was crafted by ecology experts. The record on this is uncontroverted, that it was the result of an email exchange between Ms. Marchioro and an attorney for the port over the weekend before the certification was issued for the second time with the changes that the port had demanded. So this is not an expert drafted process. It's a process that was cobbled on. It's called a work plan in the actual ecology order. And it will result in denigration of water quality, as the board found. The board, yes, could have spent 100 pages just on that part of its decision. We've given you the 4 pages the board did spend. Keep in mind, the board decision is already over 150 pages. So sure, it could have gone into more detail on lots of things, but it gave the reasons, and they're all good and valid reasons. If the board decision is not upheld, then this idea of a water effects ratio study will be allowed, which will also denigrate water quality. And I think the argument from ecology here has kind of danced around the issue. All the board said was you can do a water effects ratio study, but you can't do it if you're going to diminish the standards that would otherwise apply. And it said that because it was frankly concerned, and it gives the history of why, about the ability of the port and ecology to actually sample accurately and get a handle on pollution and ascertaining the level of pollution at the airport. That history is given very clearly in the board's decision. We've also pointed out in our briefing that there are prerequisites to using a water effects ratio study to change water quality standards, to lessen them, and those prerequisites are not met here in any event, so the board's decision made sense. You can only do that to enhance habitat, not to essentially try to vary the standards, for example, for the convenience of the port. If the board decision is not upheld, the protections that I've described will basically go away, and we don't believe the water quality will be the same afterward. And that's why my clients are here, Your Honor.
Can we go back to this water right, condition 16 again? Of course, the port is arguing this is just management of the water and not a beneficial use. Give me your best, you probably have already done it, but give me in a nutshell your best argument as to why this is a beneficial use rather than just management of water.
Well, it may be
of stormwater.
I'm sorry, Your Honor, it may be management in some sense, but the statute says, and I believe it's in, we give the site 9054, describes what beneficial use is. And beneficial use is capturing the water, managing, releasing it, whatever verb you want to use, for the purpose of, and in this case, maintaining, enhancing habitat, for example, maintaining the viability of the stream. That's defined by statute as a beneficial use.
You're talking about 9003-250. Do you know what's, do you remember?
I believe, Your Honor, that articulates the permit requirement. I think 9054 has a discussion in it of what beneficial use is defined as, but they both work
Statute
together.
says fish and water used for fish and wildlife maintenance and enhancement and preservation of environmental and aesthetic values. Is that what you were talking about?
Yes, Your Honor. And
Does this fit under that?
I don't see how it could not, Your Honor. You could say that you're doing it as mitigation, but that's really wordplay on the part of the port. It's mitigation to maintain and enhance all of those aspects that you just read. And it's for no other purpose. The fact that mitigation does not take it outside of the statute, and if it did, there would be, I think, a substantial loophole created in the law and an exemption created. It may be a good exemption, we don't think so, but if that exemption is going to be created, it should be done by the legislature, not by the port or ecology or this court, frankly.
Counsel, is it your position that the failure to obtain a water right would result in degraded water quality? Is that?
It would result in some doubt down the road, maybe not today, but tomorrow and down the road, about the ability of the port to maintain that low-flow augmentation plan in perpetuity.
Has there been any senior water right holder who has complained that this plan would infringe on current water rights that have been allocated or determined?
Well, not today, Your Honor, but...
Well, this plan's been in the works for how many years? I mean,
Well,
it seems like 10, 12, 15, I don't know. You'd think a senior water right holder would come forward and say, wait a minute, you're infringing on my water right. I'm a senior holder, and your plan here is going to funnel off water that I would otherwise have a right to the use of.
Keep in mind, Your Honor, up until very recently, the plan was to get a water right for the various zig and zag augmentation plans that the port had. This is a relative newcomer, and one of our issues, of course, is that it was brought before the board with an incomplete report. There were literally chapter headings without text in them for the port's, this particular port, low-flow augmentation plan. So the fact that no one came forward 12 years ago really doesn't mean anything, because this plan wasn't on the table then. This is a relatively new plan.
Have you introduced any evidence of any current senior water right holders?
No, the record reflects that the streams are closed to further consumptive uses, but there is no record that anyone has complained. There is a record, though, about the concern that the port will not be able to maintain this in perpetuity without the water right to do so. And if you look at it from the point of view of the code is saying, if you have the beneficial use, you must get the water right. It doesn't say only if someone complains.
Well, I'm wanting to understand how you're tying them. I mean, it's as if you're saying, well, you have to have a water right under the code. Well, but how do you tie that to water quality? And you have to make that tie, or else it's an arbitrary or capricious additional condition that's imposed by the board. It has to have the impact.
To the extent the water right is necessary to make sure the port can provide that flow in perpetuity, and it is, then it is tied to water quality. Remember that Section 401D of the Clean Water Act says that you don't just look to the Clean Water Act, but you must also look to other state laws that would apply when you're doing your review and your certification. And the Water Code is certainly another state law. I did want to address, before my time is up, the questions that were asked about the Army Corps. What is before this court is this state's review of this state's certification and clean water order. The Army Corps decision is not before this court. I could give you, and I think some of the flavor of that is in our briefs and in Professor Rogers' briefs, all the reasons the Army Corps made the wrong decision. But even Judge Rothstein recognizes in her decision at page 15, and this is critical, that just because the Army Corps doesn't agree with the PCHB doesn't mean the PCHB decision is gone. In fact, she says it may mean that the port is going to have to go back to the Corps and say, help us make this consistent. The port may have to go and comply with some of the state requirements anyway, because the state requirements have independent life and force, and they are not reviewed based on whether or not the Army Corps liked them, incorporated, or agreed with them. So that's page 15 of Judge Rothstein's decision, and that's very important here. I also wanted to address, because I think my time is short, the SPLP process question, and I think there was a question asked about, we had said it was too blunt an instrument, essentially what the board said. The record was very, very complete on that issue and very persuasive to the board because the record came from the port's own evidence. The port had already been importing fill to the site based on a permission given by Ecology that it could stockpile fill at the site. And it was using already the SPLP process to do so, saying, well, this is what we're probably going to have to do in the end, so we'll do something like this now. And therefore, we had the test runs, trial runs, many of them. And what the record showed was that the SPLP was too blunt an instrument. You had situations, for example, fill brought in from the Black River Quarry from other areas where the fill did not violated the numeric fill criteria, the limits on pollution. It was then tested on SPLP, and it passed. And the reason it passed was because the SPLP process that was used didn't go down low enough to identify contaminants of concern at the prohibited levels. So the board didn't just have to take the word of ACC or case. The board could look at the documentary evidence and deposition testimony from the port's own experts and say, well, this process is not giving us reasonable assurance. It's got problems. And that's even apart from the points raised by Professor Rogers in his amicus brief concerning SPLP.
Your time has expired, Mr.
Thank you, Your Honor.
Thank you very much. Court will be in recess until 15 minutes past 10.
All right. The Supreme Court is in recess.
This is TVW, Washington's Public Affairs Television Network.